Welcome to INN's Advocate. INN's Advocate is a platform for lawyers having less than 5 years of practice. Today we have with us Advocate Paresh Chandiramani. He has graduated his law from KC Law College in the year 2021. Currently, he is pursuing LLM from KC Law College in criminal law. His practice areas are civil, criminal, commercial arbitration, and banking laws. Today, he is going to speak on Insights of SARFAESI Act 2002. So, without wasting further time, I would request Advocate Paresh to commence with his lecture. Thank you.
Welcome friends. Today I am going to speak on Insights of SARFAESI Act 2002. SARFAESI Act, which is Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, which had come into force on 21st June 2002. This particular act is only applicable in case of secured loans, wherein if a loan is secured with a mortgage property, only in that case a SARFAESI action can be taken by a financial institution against the borrower. In SARFAESI Act, there are various modes of recovery, one being securitization. Securitization as defined under section 21Z of the SARFAESI Act means acquisition of financial assets by any asset reconstruction company from any originator, whether by raising of funds by such asset reconstruction company from qualified buyers by issue of security receipts representing undivided interest in such financial assets or otherwise. The second mode of recovery under this act is asset reconstruction. Asset reconstruction in terms of section 21B of SARFAESI Act means acquisition by any asset reconstruction company or of any right or interest in any banking or financial institution in any financial assistance for the purpose of realization of such financial assistance. And the third mode of recovery is enforcement of security interest. Security interest as defined under section 21ZF of the SARFAESI Act means any right, title, interest of any kind whatsoever upon the property created in favor of any secured creditor by way of mortgage, charge, hypothecation, assignment, etc. Modes of recovery under the SARFAESI Act. There are various modes of recovery under the SARFAESI Act, which include securitization, asset reconstruction, and enforcement of security interest. Securitization as defined under section 21Z of the SARFAESI Act means acquisition of financial assets by an asset reconstruction company or a financial institution from any originator, whether by raising funds by such asset reconstruction company from qualified buyers by issue of security receipts representing undivided interest in such financial assets or otherwise. Asset reconstruction. Asset reconstruction in terms of 21B of the SARFAESI Act means acquisition by any asset reconstruction company of any right or interest in any of the banking or financial institution in any financial assistance for the purpose of realization of such financial assistance. The third mode of recovery under SARFAESI Act is enforcement of security interest. Security interest as defined under section 21ZF of the SARFAESI Act means any right, title, or an interest of any kind whatsoever upon property created in favor of any secured creditor by way of mortgage, charge, hypothecation, assignment, etc. With regards to enforcement of security interest, SARFAESI action under the SARFAESI Act is mainly read out in section 13 of the SARFAESI Act, wherein the section 13(2) is the section where the SARFAESI Act is initiated by a financial institution, which is by issuance of a demand notice. Through the said demand notice, the bank provides a period of 60 days to a borrower to either repay the loan amount or to give a reply or representation on their behalf. with this 60 days, if a borrower fails to give a representation or fails to pay off the outstanding amount, the bank or any financial institution proceeds with taking further SARFAESI action by issuance of a possession notice under section 13(4) read with 8(1) of the SARFAESI rules. Further, if in this case, if a borrower gives a representation, it is mandated under the section 13(3)(a) of the SARFAESI Act that bank has to reply to such representation within 15 days from the date of receipt of such representation. If the bank fails to reply on such representation, even if they want to accept it or they want to reject it, they have to reply. If they fail to reply, in that case, their SARFAESI action can miserably fail. Under section 13 of SARFAESI Act, the first provision was of section 13(2), wherein a bank or a financial institution can issue a demand notice under section demand notice, giving a borrower 60 days to respond to the same. Further, if after the expiry of 60 days, the bank or a financial institution can issue a possession notice under section 13(4) or 8(1) rule read with rule 8(1) of SARFAESI Act. Once this section 13(4) is issued by the bank, it opens a door for the borrowers to challenge the SARFAESI action taken by the bank under section 17 of the SARFAESI Act. After the issuance of a possession notice, the bank cannot, that is a symbolic possession notice, the bank cannot go and directly take the possession of a secured asset. They have to file a section 14 application for taking the help or basically the assistance of a district magistrate or a chief metropolitan magistrate for the purpose of taking possession. So in this, the chief judicial magistrate or a district magistrate would appoint a tehsildar or a court commissioner to take the possession of the secured asset within a period of around 90 days, after which the tehsildar or the court commissioner has to report the same to the district magistrate or to the chief judicial magistrate. Once the possession of the secured asset is taken under the SARFAESI Act, the bank can either proceed for auctioning the said property. The bank, after taking possession of the secured asset through the assistance of the court commissioner or the tehsildar, can auction the property and sell the same to an successful auction purchaser. Within this process, a borrower can file a section 17 application before the Honorable DRT to stop the bank from either taking the possession at a first instance or they can stop the bank from auctioning the property. That is the second instance. The right of the borrower to file a section 17 application is estopped when the sale certificate is issued in favor of a successful auction purchaser. While all of this process is going on, the borrower can approach the DRT by filing a section 17 application and to stop the bank from selling the property, that is 1, from auctioning the property, that is 2, and for the same, the borrower will have to pay a particular amount to the bank for the purpose of deferring the possession or the auction at that particular instance. While if in the application under section 17 the bank wins, or basically the borrower is not happy with the said decision of the DRT, then the borrower can approach the Honorable DRAT, which is the appellate tribunal, under this provision. Wherein under this provision, the borrower will have to pay a minimum amount of 25% to the basically they have to deposit a minimum amount of 25% in the Honorable DRAT for the purpose of filing this appeal, wherein they will be able to contest the decision of the DRT and stop their home from getting auctioned. Herein, there is one more provision which comes into light. If the bank auctions the property, sometimes it happens that the amount which they receive after the auctioning of the property is lesser than the outstanding amount. In that case, the bank can approach either the DRT through an original application or through to NCLT by filing a personal insolvency resolution process against the guarantor of the particular loan account. This particular PIRP can be filed, and the borrower or the guarantor in this particular loan account will be prosecuted by the Honorable NCLT under section 95(1) of the IBC, so as to enable bank to recover more and more amount and clear the outstanding amount in the said loan account. In this particular section, further, there is an important section which gives the bank an upper hand, or basically a DRT an upper hand in when it comes to decisions taken by the DRT. No borrower can approach a civil court because of a section 34 which gives civil court to not have jurisdiction. In this particular section, it is clearly mentioned that any particular type of SARFAESI matter or a future SARFAESI action can only be challenged before the Honorable DRT, and no civil court will have jurisdiction to challenge to order or entertain the same. In addition to the SARFAESI Act, there are certain security interest enforcement rules as well, which are really important when it comes to following the process of SARFAESI. First comes is Rule 3. Rule 3, which gives that a demand notice has to be issued to the borrower through various particular means, which is RPAD, and then if the demand notice is not delivered to the borrower, then the bank has to publish the same in two different newspapers. One is English newspaper and the other one is vernacular language newspaper, in which has ample amount of circulation in the area where the borrower resides. Even a small failure in this process can lead to a devastating failure of the entire SARFAESI action taken by the bank. The next rule is Rule 8, which, as I had mentioned earlier, the Rule 8(1) notice of possession. This possession notice has to be issued in accordance to Rule 8 of the security interest rules. If the possession notice does not get delivered to the borrower, in that case, it has to be published by the bank within 15 days from the date of issuance of such notice. Then comes Rule 9, which is very clear with regards to auctioning of the property and the process of auctioning of the property. Herein I would say that the SARFAESI Act has given a really good median for the banks to recover the outstanding loan amounts due as compared to the prior period before SARFAESI Act, wherein the bank only had a few mediums, for example, filing an original application before the DRT and or filing a suit before the civil court, which was a time-consuming process. But now the bank, through the SARFAESI action, can overtake the filing of civil suits and overtake any filing of any kind of applications before the honorable courts and wait for the orders for taking SARFAESI action. This has in turn helped the banks to recover a many number of NPAs. Thank you.
Paresh, thank you very much. It was a crisp presentation as regards the overall SARFAESI Act. So thank you very much. A small token from Hammurabi to you.
Thank you.